Good morning. Today is January 9th, 2025. Welcome to another episode of Legal Grounds Morning Cup. I'm your host, Texas consumer real estate attorney Benjamin Sanchez. Today, I will briefly discuss the three primary duties the insurance company has to you when a claim is made against you. So join us for another edition of Morning Cup. In Texas, and generally throughout the United States, an insurance company has three primary duties to you, although there are lots of other duties. But I want to cover at a high level the three basic primary duties that an insurance company has to you when a claim is made against you. One is to deal with that claim and you in good faith. Two is to pay a covered claim potentially up to the policy limits. And three is to defend you against a covered claim. So let's go over each of those in a little bit more detail. One, good faith. What does good faith mean? That means that the insurance company can't act improperly or in bad faith when trying to deal with a claim that is a proper claim, that is covered under the policy, and that should be settled, and that could be settled so that you don't, as the insured, don't have to pay money. Sometimes insurance companies want to lowball the claim, even though the claim may be worth more than what they're willing to pay. And as long as it's in the policy limits, it should be okay. Furthermore, they have a duty to deal with you as the insured in good faith, keep you updated, keep you notified, to let you know what their positions are. Sometimes in a claim, you will get what's called a reservation of rights letter, which means that the insurance company, at least preliminary, is going to cover the claim, but they reserve certain rights later on if they figure out or they determine that the claim is not covered. So again, the insurance company has a duty to deal with you and the claim in good faith. If they don't, they can get in trouble for that under the Texas Insurance Code because they have a duty to deal in good faith. Second is they have a duty to pay a covered claim potentially up to the policy limits. Now, it doesn't mean that every claim is worth the policy limits. If you have a $100,000 policy or a $300,000 automobile policy, and you have a minor fender bender, and potentially the medicals or the damages that are proven up are, only worth a lot less than that. Let's say $25,000 on a $100,000 claim. I mean, obviously, the claimant is going to want potentially to get as much money as possible. If they have an attorney, they have to account for attorney's fees in making that claim. However, the insurance company can still have good faith and deny a policy limits claim potentially. Now, they take a risk in doing that because if they deny a claim for the policy limits and later on the claim is worth found in trial or something to be policy limits or greater, then they would be responsible for that extra amount. But generally speaking, that second primary duty is that when there is a covered claim, the insurance company must pay potentially up to the policy limits depending upon the facts of your case. And the third primary duty, and the one that sort of we deal with a lot in this firm, is they have a duty to defend you against a covered claim. Now, some insurance companies will take their time in making that decision as to whether or not a claim is covered. And so if a claim is not covered by the insurance policy that you have, then that duty to defend you does not start, right? There's no duty to defend by an insurance company if there's not a covered claim. So, for example, if you have, let's just say that you are a business owner and you have what's called general liability insurance to cover personal injuries on the job or personal injuries at your work of your business, but then you commit some sort of negligence on your job, generally there's a separate type of insurance for what you do on the job versus personal injuries at your workplace. And so if you have a personal injury in your office, your CGO company may end up covering that, but they may not have a duty to cover somebody getting hurt on the job. That could potentially be another policy. And so they wouldn't have a duty to defend you or your company in that situation where they would in a personal injury. Now, all of this is very high level. And the reason why I say that that last one affects us is because what we see in our firm is two things. We do some uninsured defense. So we don't represent insurance companies. We're not in the business of making personal injury claims. We're really not in the business of trying to make a habit of defending insurance claims. But what I saw a need for in a lot of my consumer clients was that they either had no insurance when something happened, and so they still wanted an attorney, but there was no insurance company to defend them, right, to provide that attorney. So we step in and offer uninsured defense. Our clients have to pay us for that. It's not paid, obviously, by any insurance company. And therefore, we at least provide a defense so there's no default and there could be some challenges to that claim. The second thing is that sometimes insurance companies will take their time and they will not process a claim, quite frankly, in good faith, or they will delay their decision on the claim. Meanwhile, you've been sued. The clock is ticking for you to get your answer on file. And so we also step in, not because we're necessarily going to be the primary counsel for the rest of the case, but we give our clients that bridge that gaps the claim to the insurance defense attorney. So we step in, and our clients do have to pay us for this, unfortunately, and I don't think that you're going to get reimbursement from the insurance company, although you can try. But generally speaking, our clients want to make sure that they cover themselves and that they don't get a default or whatever. So they will hire us to step in, to file the answer, to maybe do the initial discovery if the insurance is taking that long. Generally speaking, we will cooperate with the insurance defense counsel once the insurance company decides that it is going to cover the claim and that it does have that duty to defend. Then we will be substituted out, and the insurance company's choice of counsel, which they have a right, will step in. So we either bridge the gap, or if someone doesn't have insurance, then we will certainly step in and do our best to defend. Unlike an insurance company, we don't go out there with medical experts and all that kind of stuff. So again, we're not an insurance defense counsel. We're not hired by any insurance companies, but it is a service that we offer to people who either don't have insurance or are getting delayed coverage by their insurance company. I hope you have a great day. This has been another edition of Morning Cup, and I look forward to speaking with you again tomorrow. Have a great day. Bye-bye.